Okay, this is Julio Zamora. Today is Saturday, September 29, 2012. I have a notation I want to put here that I filed a request for dispute resolution before the Administrative Director, DWCAD 10133.55. Okay, case number 25009-25228. Uh, Case number ADJ 727-7670, ADJ 688-1044, ADJ 836-1199, ADJ 729-6751. I'd also like to note that I made a notice of application, date of service 6/1/2012. EAMS case NBR number is ADJ 836-1199. Date of claim of injury was 12/7/2009. Um, and I made that claim, like I said, on date claim injury was 12/7/2009. Actually, the injury was before that, but the claim was filed on 12/7/2009. The date of service was 6/1/2012. Okay? And this was an application for ADJUDICATION of claim. Has been filed with the Workers' Compensation Appeals Board for the above claim injury. Please reference the above EAMS case number on all correspondence to the WCAB. This notice constitutes a conformed copy of the application. Date application filed was 5/31/2012. Okay, so that was sent to the Division of Workers' Compensation Appeals Board. So I want everybody to realize that, and that's going to be for the court. And I also like to note that on 12/7/2010, they took my lifetime medical insurance away from my family and myself. They just stripped me of it all. And if you have any idea how much money that is, that's a lot of money. A lot of money. Just because I received an offer of work on 12/1/2010, they stripped me of everything. And I had an active FMLA, which I should have been able to obtain medication, but I was not allowed because they stripped me of everything. Okay? And I'd like to make that for the record, and that's going to be part of my statement for the court on October 31st, 2012, because they refused me to have a treating physician. And this is the second notice, but actually it's the third notice. But it's my second notice request for a change in treating physician. Okay, this is Julio Zamora. I'm trying to make a recording for the court for workman's comp. Today is September 27, 2012. I'm going to start off with this offer of work that I received on December 1st. Went to work on December 3rd, was sent home on December 7th, 2010. On the offer of work, it stipulates the employee must accept, reject, or object to this offer for regular work and return this form to the employer or claims adjuster listed on the form within 20 calendar days of receipt of the offer, or it will be deemed that the employee accepted the offer and has waived the right to object to the location or shift. Okay, and this was, I received this on 12/1/2010, and like I said, I went to work on December 3rd. On December 7th, 2010, I was sent home. And I should also like to note on this notice of offer of work, it's on a notice of offer of regular work for injuries occurring on or after 1/1/05, form number DWCAD 10118. Okay, and this form was completed by the claims adjuster, Luceria Espinoza. Okay, and the starting date was 10/13/2010, but I didn't receive it until 12/1/2010, and it was mailed to me from Phoenix, Arizona. Okay, and I should like to also note that this position provides wages and compensation of $6.56 weekly wages. They are equivalent to or more than the wages and compensation that will be paid to you at the time of your injury, or was paid to you at the time of your injury. This position is expected to last for a total of at least 12 months of work. If this position does not last for a total of 12 months of work, you may be entitled to an increase in your permanent disability benefit payment. Okay, and that's what it says. Notice of offer of work. So I should be working. They shouldn't have sent me home on December 7th. Because I didn't have 20 days to decide anything. In fact, from the 1st to the 7th, it's only 7 days. And I was on FMLA and they just sent me home. And they stripped me of all my medical benefits and treatment and medication, drugs, whatever. I also had a lifetime medical, which I lost. Okay, and I also like to note that I took a physical DOT examination on 10/1/2009 and then expired on 2011. And that in 2009, I took a DO test with Dr. Yip and the company doctor. Either 2008 or 2009, the company doctor took a DOT examination. On the back, it says I need hearing aids. It says wearing hearing aid. So I need hearing aid. They need to accommodate me because I filed a claim on 4/13/2009. So they knew that I have a hearing problem. And the dispatchers knew it also. So that being said, I went to the doctor for my hearing on 10/10/2011 when I found out that I had a hearing problem. Because they didn't send me to a hearing doctor or anything else. They just completely ignored the issue. And they're still ignoring the issue and it's not being brought up. But I presented a document in the last hearing at Workman's Comp, severe profound hearing impairment. And then also, I mentioned the fact that I needed accommodation needed for trial, including special hearing aids. And I also handed in that they need to be purchased at Kathy Tova Tower Center for Better Hearing, 1801 Colorado Avenue, Suite 150 in Turlock, California. Phone number 209-216-3300, or by the court, as you all know. I said, please reply by December 5th, 2011, if there are any problems. So, nothing happened. They just completely ignored it. And the doctor said I had a severe profound hearing impairment, and it's been ongoing. So, that's the thing with the hearing aid. And I have a prescription and everything I have. I'm also going to turn in an MRI for my lumbar spinal thing that I had when I was in the hospital. I went to Los Angeles Hospital on 4/5/2009. I was out of the hospital the next day at 4/6/2009. I seen Dr. Hubby and I gave her a copy of the referral or the MRI stating I need to go to Dr. Baby because I have a pinched nerve, low back, according to the hospital report. Safeway denied this, stating that Nancy Perdillo stated that it was a sprain because I didn't see a doctor or have x-rays or anything else on 3/21/2009 when I seen Nancy Perdillo. Of course, I had to follow up with Dr. Hubby on the 22nd. She wrapped my leg and sent me home. I had nothing. So, anyway, I'm going to give him the doctor's report. It says, Doctor, first report of occupational injury from Los Banos Memorial Hospital. And it says that I went in there for left leg pain, the same that on 3/21/2009. It's typed in this form. And then they object to finding C below. Low back pain, radiology, MRI. So I'm turning in the MRI with that statement. And I'm also turning in the 4/13/2009 for my hearing impairment. Okay, so we have those issues, and I'm also turning in the National Better of Health Attention Robert Neiswanger, so the union knew that I had an FMLA and it was active on December 7, 2010. I'd also like to point out that I was denied 2 appointments, cancellation appointment notes. I'm going to hand in one of them from Safeway Attorney, Workman's Comp Attorney, Valapo, Joseph Valapo, okay? And I'm also turning in a copy of the envelope showing that I received this document on 12/1, the offer of work. And I'm also going to turn in that agreement was filed by Safeway or reference discharge on December 16th, but it was received December 17, 2010, General Teamsters Local 439. And on the left-hand side, it says Local 439 via fax mail. Safeway faxed this document. Down below it says Employee, DC Director, Labor Relations. No one was informed. This letter was between Mr. Neiswanger and Mike Sadler and no one else. I did not receive a copy of this letter, reference discharge. And it says I was discharged on December 6, 2010, and I went to work on December 7, 2010. And this letter is dated December 16th, going back to December 6th. Okay? Now, Mr. Neiswanger responded on December 7, 2010 that in accordance with Article 25, 26, and all articles of the CBA, consider this a formal grievance protest in the unjust, improper, without just cause discipline issued to Mr. Zamora in a letter dated December 16, 2010, in violation of Article 25 and all other applicable articles of the CBA, etc. There's no doubt that they violated all those articles, and I'm going to state the reason why. They did not complete Step 1, null and void. They did not complete Step 2, final and binding. Did not file a written agreements within 10 days. Did not send registered mail. I was never informed. Okay? So that's the reason the discharge was denied. It violated all articles of the contract. Okay? And down below it, it says the local union requests the discipline be denied, grievance to be returned to work immediately, and agreement to be compensated for all lost time and benefits. Please provide a date and time to discuss the grievance in accordance with Article 26 grievance procedure. Now I'm going to read one more paragraph because it's very important and the judge should know this. Additionally, provide any and all supporting document, notes, strip sheets, videos, and statements surrounding the investigation and discipline issued to Mr. Zamora that the company relied upon as soon as possible, but no later than December 25th, Christmas, on 2010. It didn't happen. They didn't submit anything, nothing, not one piece of paper that I'm aware of. And I called Neiswanger, I think on the 16th, and I also called them before Christmas, and nothing was handed in. In fact, they set a meeting for January 11, 2011 at Safeway, Tracy, California, 1-800-388-2125. And this was emailed to James Williams, Transportation Manager. And it says here via email, jameswilliams18@safeway.com. And I should also note that this was sent by Robert Neiswanger, business representative, to Ben Pelosi, Carl Ramirez, Safeway Labor Relations, Ed Speckman, Mike Sadler, and Julio Zamora. This was mailed. It wasn't registered mail, and I was informed by the union and not by the company. Not by the company. They're required to send me registered mail. They didn't do so. On top of that, they didn't prove anything on December 25th. And on top of that, they didn't respond within 10 days to set up a meeting or anything else. And why they continued on, I don't know, when the discharge was denied. And that's about the extent of it. The discharge was denied. They didn't respond in 10 days. They didn't respond in 20 days. They didn't respond in 30 days. In fact, they didn't respond at all. I had a meeting January 10th with Mr. Niswanger. We don't need to go into that because the discharge has been denied. Okay, the last important document is that I filed a 132A. Okay, I filed a 132A because of said action. I didn't get hearing aids. I didn't get a change in position, and I asked more than twice or three times since 2009. I didn't receive proper medical treatment or I was denied. I haven't been paid. I should be working. I haven't been paid since December 7, 2010. And they stripped me of my lifetime medical and the FML medical, which I am required to have. If they took me off the job, they took me off the job illegally, and I should be working. So I filed this 132A dated February 11, 2011. It was submitted by Adam Stewart because they're in violation. And I'm asking that the applicant be reimbursed for lost wages, prejudgment interest, and all other compensation under the provisions of the Labor Code Section 132A and be reinstated to my job. Because I'm still working there, but I'm not working there. They haven't called me back to work. I'm on standby because they didn't let me log out of the tractor or let me clock out of the truck, in which there is no time card, and I don't get paid by that time clock. They have two time clocks. One's a log for the logs, the automatic onboard recording device, and the other one is a time clock with no time card, and you don't get paid by that clock because there's no way to show or prove that you even worked after you log out of the tractor. Automatic onboard recording device would put you on duty at 10:30 in the morning every day you come to work. As soon as you hit that property or guard check, you're on duty. When that guard signs you in on Safeway Tracy Distribution Center, you are on duty before you even get to the dispatch office. Once that guard signs you in, you are on duty. But they require you to use the time clock to clock in. Why, I don't know, when you're already on duty. I don't know. So anyway, I filed the 132A on, again, dated February 11, 2011. That's my statement for the court. I'm asking to enforce the 132A that I be returned immediately and that I be paid the compensation of $1,000 plus every week that I've been off, because the fact is the offer of work states that I hadn't had a chance to respond in 20 days because they sent me home. So automatically they have to work me, and they didn't do so. They violated 132A. That's my statement for the court. Today is Thursday, September 27, 2010. I'd like to note that that you got to remember in the back of your mind that that I have an onboard recording device in the tractor, and that's what I get paid by my logs. Okay, and I'm under DOT regulation 14 hours on and 10 hours off. And the second time clock in the driver's room does not have a time card. It doesn't show anything. You don't get paid by that time clock. And it doesn't record the miles. It doesn't record anything after you log out of that tractor on the onboard recording device that we get paid by. Okay? And again, I like to note again that when we come into the Safeway property and we have to check in at the guard shack, as soon as he signs us in, we are on duty. Again, we are on duty, okay? And that's how it goes. And it's been that way for 10 years. I'll be there 10 years this August 2012. And I'd like to note that I would appreciate some consideration in this matter for the fact that the unemployment office, that I was on unemployment from 4/17/2009 all the way up until 2012, and according to the letter that I received from the unemployment office, it's conflict of liability. Okay, they don't have any right to decide anything, And I'm going to send a copy of that with my statement to the resolution board for judgment, and I'm also going to send a copy to the judge on October 31st. They don't have a right to decide anything, and they need to repay the unemployment office. Okay? So that's my statement for the court, and I got to remind the court they took my lifetime medical away. That thing is worth a lot of money, and they had no right taking it. And I'm asking consideration to the court to return me to my job, etc., whatever is fair and equal under the law. That's my statement. And today is Saturday, September 29, 2012.